3 को कब फाइल की अभी फाइल कर अडॉप्शन का लिख दीजिए like for the section 14 order.
Yes, it is section 14 order has been dismissed.
To dismiss.
This in this case now, the DM has traveled beyond the fiction, travel into the merits of the case and dismiss the that order has been filed as with the P2 member, whereas in page number 20 member in second paragraph. from the एवं में बंधक संपत्ति ज्यादा मूल्य के नैसर्गिक न्याय के दृष्टिगत एवं मानवीय आधारों पर नैसर्गिक न्याय और दृष्टिगत एवं मानवीय आधारों के आधार पर विधान पत्र स्वीकार किया जाना उचित एक्चुअली एक सिमिलर
कर सकते हैं let him come forward and also say file an affidavit of the petitioner.
दूसरी पिटीशन से हमने की एप्लीकेशन फाइल की वो उस नंबर के साथ
all right then we'll just because with this IA for restoration file IA for recalling of the order final order dated so and so by which the WP so and so had been dismissed as having rendered infructuous based on the statement made by the counsel for the petition. Next one. The said application recall is duly supported by the affidavit of the counsel or the petitioner in WP so and so. Contains that the cause raised in WP so and so had not become. Next. Accordingly, IA so and so is allowed. WP so and so restored to its original number to be listed in the next week. Next week. Modification.
of the letter by the first February level. The most mentioned is 5 wala. Instead, the case is mentioned in except one. It had 3 and 6, the post. Except 3 and 6. वाणिज्य विभाग में CCTC commercial कम ticket that's the post level. Which is in question in the petition one.
Appointment to the post of
CCTC commercial come ticket clerk.
CCTC.
2 cases in the order.
The para 3 and para 6.
Yes, sir.
Can you show us from the record?
Well, extra A1. Internal page 12.
Hello.
Petition.
Otherwise, OA has me. You must have filed the OA copy.
Yes, sir.
That was P1, P2. Kya tha? Who was appearing for the other side? The main case. Yadav was there. Is he there present in the court? आपके OA में भी सफाई वाला ही लिखा है. That is the problem. How do we
order was approved? Actually,
Have you served a copy on Mr. Yadav? No, Mr. Yadav was appearing last time. So it will be convenient for us that if notice is given to him. Mr. Yadav आए हैं क्या आज? अच्छा। कल लगाना पड़ेगा। और लिखिए इसमें भी IF और IS also modification of the order, final order passed also filed on the ground that is filed with the prayer that the expression safai wala found in the said order, the modification in paragraph 3 and 6 be substituted with CCTC. Next part. After having gone through the record, it appears that though the petitioner had CCTC in place of full form equivalent, five found in paragraph 3 and 6 of the order under review. Remaining part of the order shall remain intact, disposed of.
3/4 with corrected matter, he said that other supply.
Going for any interim order? For adjournment, since the arguing counsel is on his legs before another court. Just not 4 weeks time to comply with the cost part. File the compliance report. List after 4 weeks. We'll take up, there are 4 or 5 more motions. We'll take up that and then come to your case.
The registration was required to be filed as files. Along with all the requisite documents. You have to put in the process and for any bulky record of appointment of over 11,000 candidates. And we don't take to file that registration. In fact, I have just signed a copy by the commissioner with them. And we are required to, and you also had on the last day that a common to be filed, but we got a copy from them. We are required to.
We are also doing it at our end. Just some more time. No, as far as tabular, as far as I'm concerned, Lord, we should be sanctioned. Therefore, for that tabular that we are making, because people involved in the production done a lot of. Therefore, we wanted to be pitch perfect about it.
Can we dispose of all these cases and say that the judgment of the Supreme Court will be followed? That's all. You follow the Supreme Court judgment. We have not adjudicated anything. So you read it, understand it, and implement it. If somebody has a problem, will come to the court.
My lord, first, my lord, will be done. ID number 528. We start the last date of hearing, no reply has come. In that, Lord, that KC Nandan, Lord, and Rohit Chaudhary, both of them, my lord, have got appointment. So as far as their petition is concerned, that can be dismissed as having become in practice. Because that is it. Because service matter PIL is not maintainable. And this is not a co-warrantor, nor is this the scope of co-warrantor. But co-warrantor is right after the appointment. My learning friends also know it very well. So Lord KC Nandan may be dismissed because I have not received reply to 5284. My lord was appreciating that argument of mine in the last case of hearing, I remember, that there are only 2 petitioners in KC Nandan Sahu, and both of them have got appointment. Nothing remains in this petition. This petition may kindly be dismissed.
Lords, I appear for the petitioners in Kesari Nandan. If your lordships can just hear us for a minute. After the Supreme Court's order, which has been passed, which is dealing with the substance of, I'm sorry.
He order, he had not interveners in KC Nandan Sahu. So, Lord, I was saying, as far as KC Nandan Sahu is concerned, because PIL is not maintainable, Lord, in service matters. And this is not a case of co-warrantor, nor is the scope of co-warrantor like this, my lord and my learned friends are well aware. All of us are practicing on service matter side. So, therefore, only thing is that KC Nandan will have to be dismissed, provided you file a reply to 528.
Okay. We'll deal with that later on.
Let that.
But there is a request made by the state that there is more time for filing that table. Now, the suggestion of the court to the state is that since there is no question of any adjudication, because that has been done by the Supreme Court. So we will say that the state should follow the Supreme Court judgment.
But
That's
I
fine.
am for the selected candidates, my lord. We are all right with that. Let the state take a call. And because according to us, we are covered by that order completely.
Lords, that will have another round of litigation then, clearly from the positioning that is being taken. Because I can show to my lords that my lords have passed at least 3 interim orders saying that all appointments will be subject to the outcome of the final in the writ petition. Now, the Supreme Court's order, which has been passed.
Is it doubtful?
I beg your pardon, my lords, I couldn't hear.
Either you say it's ambiguous.
No,
It's not clear.
My lord, is absolutely crystal clear. It's only if the person who is appointed had filed a petition and got an interim order
That is not said.
Will not be. He will not.
No, I
be
think
protected.
Mr. Patwale has
Otherwise, he will be
misunderstood
clearly
the order.
protected.
Completely.
That's
That
the
is
whole
the
intention
Best
of the
thing is to
order.
read the order, my lords.
Yes.
There are
My lord
only
said-
2 conditions that are required. The first condition is that the person should have been appointed, a B.Ed candidate should have been appointed prior to the date of the Supreme Court's judgment. The second condition, if that B.Ed candidate wants to continue to have the protection, that B.Ed candidate should not have had his appointment made subject to any order of a court. In our case, as far as Madhya Pradesh is concerned, after the advertisements came, challenges were brought before this court, including in Kesri Nandan's case. Your lordships passed not one but two interim orders. The minute those interim orders were passed, the guillotine has fallen on all B.Ed candidates who wanted to take advantage of the NCTE notification.
That's a
That's all the
misreading of the order.
interpretation is.
The order
So
is very clear.
we can
It
show your
says would be
lordships
subject
the
to final
order. We have
outcome.
filed a compilation.
It might have been
Mr.
instituted by
Patwale is
then.
for an intervener. I'm sorry. Can you allow me to complete? I'm the petitioner in the first lead matter. We have others have also intervened. Let me just argue on behalf of the petitioner. We have filed a small compilation, my lords, to put everything in one place to make it clear and simple. If your lordships can just take that.
Is it the court?
We have to take it back to the department.
Yes, we have placed it before the court.
There are 1,000 people, maybe 10,000 people. So how many will come back? Not more than 5%.
No, we don't miss.
Absolutely right, Munot. Let the
That's
state
11,000.
take a
Let's-
call as to what is
It will
to be
get
done.
opened up all over
affidavit,
again. The
1
idea
minute
behind the
mis-
Supreme Court reviewing its own judgment and giving a final judgment was to ensure that nothing more will trickle up, my lords. I'm just suggesting your lordship may see your orders and the advertisements. That will put everything in the clear.
My lords, as per the state government in its affidavit filed before the Supreme Court, the dates of appointment are crystal clear. Those dates happen after the orders passed by my lords, including there was an impleadment filed by these candidates before the Supreme Court, and Supreme Court had itself in an order said that the all appointments or whatever in the pending proceedings will be subject to the outcome. So not only was this court, but there was also the Honorable Supreme Court's interim order there.
Can we just show you the Supreme Court's order, my lords? It's April. That's the only thing of which an interpretation is sought now.
Kesri Nandan and Rohit Chaudhary.
No,
So
we-
that petition should go on. Why they are opposing, I fail to understand.
So, Rupra, we are dealing with the real issue. Your issue is not so real as the issue of, let us say and let us take out that Supreme Court judgment and take out points, because we were hoping and expecting the state to assist us. But the state seems to be,
Therefore, we opened by submitting that on 15th.
because there is no adjournment, no adjudication left now. There's no adjudication.
The state has to come out with a stand as to what they are doing, and ultimately whoever is aggrieved can have redress against that.
Parties are directed to find a common ground.
Well, if you take up the compilation which we have filed on behalf of the petitioner,
And therefore, that-
Only to assist the court. Now if the court does not need your assistance, you prevent the court from going ahead.
I'm only teaching this honorable court.
Because the entire adjudication has been done by the Supreme Court.
Absolutely right.
Do that.
Absolutely.
We don't have to indulge into that.
It's almost ready. We have received from my.
there's no reason for the state to continue delaying like this.
That's fine. We'll deal with that as per we'll say that state government should implement the Supreme Court judgment.
But can we just drop one interpretation, because rather than open it up in future,
Make that clear. That is why I am repeating, emphasizing my point. Supreme Court judgment deserves to be implemented.
My lords, may I make a submission here, if my lords may permit me?
Deserves to be implemented
My lords-
in respect of Vipin Kumar Dwivedi and all those advocates.
Goes out and who remains in service and who gets out. That is all to be identified. That's all.
It's an important issue.
Yes, sir.
There is a writ petition in the varg. The petitioners are appointed already. How can they maintain the writ petition? There are so many issues which have to be addressed before the Honorable High Court.
That we'll deal separately. We'll deal separately that Mr. Rupra's objection. We'll deal that separately.
So therefore,
would your lordships have the court's order, Supreme Court's order?
under the comment
we have already almost prepared it. But it is not going to fall by, I don't know why my member friends are objecting to it. I don't know if this matter is posted the first week of May. Let it be heard on any day. We commencing from 1st of May.
My lords, if we may see the history of this matter and the number of times the state has asked for an adjournment, on the contrary, in the last proceedings, my lords, this comment that the state is deliberately taking a position which it should not be.
Because she is in Casey Nandan.
If-
But please, just beat out these cases, Lord. One is Casey Nandan.
Let's not get into locus standi now. There's a Supreme Court order at your behest.
A
at the
PIL
state's
has to be
behest.
rejected at the outset, my lord.
The
The
state
PIL
of
cannot
Madhya
be
Pradesh has
maintained.
gone to the Supreme Court and got an order. That order has to be implemented. Can we just see that order now?
Either you say that PIL is maintenance service matter, show me some Supreme Court ruling. So, Lord,
I say this, my lords, let's put a quietus to this. There is Kesri Nandan and there is Vipin Kumar Dwivedi. There are two matters before my lords and they both are available for my lords for
I
consideration.
don't know why my friend keeps saying it's a public interest litigation. If he at least reads the papers of that writ petition, you will see it is a writ petition on behalf of DL-led candidates. I don't know why it suddenly become a public interest litigation.
because
This is obviously just a scheme to try and interrupt us when we are placing the order before the court.
It says, I read that the instant petition was filed challenging these notifications, whereby candidates possessing B.Ed were made eligible for post of primary school teachers. Petitioners also participated in the same process, holding the degree of DL.Ed.
Precisely why it's not a public interest litigation.
For the post of primary school teachers in the same selection process, which they are challenging. The name of petitioner number
It became a
1
public interest.
dated 4/4/2000 of district Anupur at serial number 225, that is filed here as an action IA1. The name of petitioner number 2, Rohit Chaudhary, is mentioned at serial number 25 of select list dated 4/4/26, 4/4 IA number 2. Both the petitioners have joined on the basis of the said orders dated 4/4/23, IA1 and IA2, and are working in district Anupur and district Dhar respectively as primary school teachers since last about 1 year. Their employee ID has also been created.
My lords, may I make a submission to cut this short? There are two matters before my lords. Vipin Kumar Dwivedi and Kesri Nandan, my lords may hear us and then decide, hear them later on that.
No, but
But,
without
this-
they have no right to address the court.
I can't understand. That's for my lords to decide later on after we have put our case.
Or the BA candidates go out of the court or not? How Lord Kesri Nandan or Rohit Chaudhary is going to be affected? That is the good question.
In fact,
Kesri Nandan can argue, Vipin Kumar Dwivedi are prepared to argue right now, but no counsel should buttress the case of Kesri Nandan and Rohit Chaudhary.
I will. I fully insist that I will.
First, kindly address on Locus. Who are you?
Mr. Luthra should clarify whom is he appearing for. His intervention till date is not been allowed. Who is he? He's not a respondent in my matter. How can an intervener whose intervention is not allowed have the first audience at all?
It's allowed, intervention is allowed. That was allowed long back. Insisting now that this Kesri Nandan has been rendered infructuous because both the petitioners, they already have been appointed. And having participated in the same process of
All right, we are resolving the cases and we'll try to decide the cases. If it's difficult for us, then we'll release.
My lords, as the petitioner in the first matter, can I have 2 minutes?
If certain facts are evident from the pleadings, I think it should be evident from pleadings.
My lords, then in that Vipin Kumar Dwivedi, can I point out three
Can we
orders?
make just 2 minutes of submissions on behalf of the petitioner? Just 2 minutes, that's all. It will not take more than 120 seconds. Yes, my lord. It's simply this. If you look at the order of the Supreme Court, there are very clearly, it states, your lordships have seen the order, then I'm not going to trouble your lordships with it. But I'm just reading out 2 sentences from it, which is the relevant portion of it. It says that before us, 2 sets of parties are there. One set wants retention of the said judgment in its present form. The opposing side alleges that it would result in loss of employment to those who were already appointed as teachers in different states on the strength of their B.Ed degree. this B.Ed qualification was what was struck down by the Supreme Court. It is submitted that they had entered their employment following a legitimate course as per notification issued by respective appointing authorities,
Where
which
are you
did not
reading?
stipulate.
Where are you reading? In the order?
This is in the Supreme Court's order, page 5, and this is what we are relying on. Prospective operation of this judgment shall be only for those such candidates were in regular employment without any disqualification and were appointed in pursuance of a notice of advertisement. This is the second condition. Appointed pursuant to notice of advertisement where B.Ed was stipulated to be valid qualification.
Yes.
Services of only such candidates shall not be disturbed because of this judgment. We make it clear that this benefit is only for the candidates who were appointed. Please note, appointed prior to the date our judgment was delivered, that is on 11th August 2023. Mere selection of such candidates or their participation in the process will not entitle them for a benefit under our present order. I'll just give your lordships the relevant dates, my lords. The first advertisement that was issued was on 6th January 2020, after which we filed our writ petitions, my lords, in which, and this is why the locus point keeps coming up, we asked for not only the striking down of the NCTE notification, but also that B.Ed candidates not be made eligible. Even in the future, if they are allowed to take part, it would affect us. The High Court passed interim orders dated. Please note these dates, Mullah, this is relevant because both these dates are before the Supreme Court's order. 7th July 22, your lordships passed an interim order. 7/7/22.
My learned friend is not here. I expect to never want to.
Pursuant to which some of these people went and intervened in the Supreme Court.
You see, it does not survive. Why my learned friend is not addressing?
Surely I can complete what I'm saying. The first interim order is 7th July 22. The second interim order is 16th January 23. 7th July 22 and 16th January 2023. The order of the Supreme Court, the judgment of the Supreme Court, which is the cutoff date, is 11th August 2023. Now, of our friends who have been appointed, I'm sorry.
Taking your ownership to the judgment of the Honorable Supreme Court. Now, we are not quarreling on the issue that some judgment is pronounced by the Honorable Supreme Court, and it has to be implemented. There is no quarrel on this issue. But then the point is, how to address the Honorable.
I'll just take half a minute to complete, my lords. We had the same problem in the Supreme Court because people who are anxious to protect their jobs are obviously very anxious. I can understand that. I'm just stating the facts now.
Your clients, Mr. Shankar Narayanan,
Yes, my lords.
are diploma holders.
Yes, my
Yes,
lords,
we are
both
DLED
clients.
holders. We are the only ones eligible for
They
these
have
posts.
been appointed. They have been appointed.
They've now been appointed. Now, yes.
All right. So, so they will not be adversely affected by this Supreme Court.
The B.Ed candidates who are senior to me, they are the ones who are going to affect me. All of them have to be out. If they, as per the Supreme Court's order, if they did not have the protection of an interim order,
Yes.
then it's a different matter. Here there was interim orders which protected us, all of us as petitioners, and said that it would be subject to outcome. And those interim orders were passed prior to the cutoff date, which is 11th August 23. 2 interim orders were passed. And, my lords, the Supreme Court has said you must look at the dates of appointment.
That is evident from the record.
If I may now, if my friends 2 minutes are
Yes,
over, if I
we are
may.
drawing your lordship's attention to 2
Before-
facts. One, the dates of the interim orders.
This is what they did in the
2,
Supreme Court. They didn't allow the other side to argue.
appointment.
We
The
go
dates of
through that.
actual
We go through the record, Mr. Shankar.
Lord, may I just have
Very
2
well,
minutes?
then I won't
May
say
just
anything
have 2
further.
minutes
My
from
lords,
the
can
other
I,
side?
before
Lord.
Mr.
Now,
Patwalia starts,
before
I
the
am for the
Supreme, just 1 minute,
petitioner.
1 minute.
Patwalia, I
They
am
are
for
both
the
on the same
petitioner.
side. Please let me present the other picture.
My lords, can I appear for the petitioner and then Mr. Patwalia can argue?
Lord, they are both on the same side. So
My
let
lords,
me
that's not
present
the
the other
case. I
picture now
appear
that
in
one side
another
has been
matter and I
presented.
want to point different facts. Please do not do that, Mr. Patwalia. I appear in a different matter with different
This is
facts.
what happens.
You
Anyway, I'll
did
wait,
the
Lord.
same thing in the Supreme Court, not
I'll
allowing
wait.
anyone to argue. Please, don't
I'll wait.
repeat it now.
Yes.
My lords, I'm going to be very short and crisp. I won't take longer than at least a couple of minutes. Now, my lords, can I just say one thing? The crux of the matter is the Supreme Court says the appointment had to be without any disqualification. The submission that we make before my lords is that in the writ petitions that were filed well before.
Lord, I have to make a point. Lord, I have to make a point. I am on the other side. My point is this, Lord.
My lords, there are four interim orders. There are
Lord,
four interim
Lord,
orders.
let me make my point. Lord, that's what they want, that they should argue. Other side should not argue. Matter should be reserved. Now, the other side is, before the Supreme Court, there were two kinds of B.Ed candidates. One B.Ed candidate was where the candidate himself had gone to the Supreme Court because the state had declared him ineligible. Now, the other were where the state was declaring them eligible under the notification.
Find BA candidates. No, we have not filed any petition by them. That is the order.
Yes, I agree with my learned friend. Just kindly read one line of the Supreme Court order, my lord, which appears had already been appointed on the basis of eligibility criteria specified by the educational authorities. We do not think it would be. We accordingly hold that the judgment delivered by this bench shall have prospective operation. But prospective operation of this judgment imposed by any court of law to the effect that their appointment would be subject to final outcome of the case, which might have been instituted by them. Why? Because Rajasthan had declared B.Ed ineligible. In Rajasthan, the B.Ed candidate had gone to the court and wanted to appear. The B.Ed candidate appeared provisionally under orders of the court, even though he was not eligible as per the Rajasthan advertisement. Then he lost, and therefore he is ineligible. A similar position happened in Chhattisgarh. Chhattisgarh decided against the B.Ed candidate. There, the B.Ed candidate went to the Supreme Court. The rule still holds valid up to today. We have been appointed.
Sorry, this is
our appointment
completely
order
preposterous.
does not contain any condition that it is subject to anything. We have an absolute appointment letter in our favor. And the Supreme Court therefore says, only if the B.Ed candidate has got some interim order and got appointment on the strength of that interim order, only then he is not to get the benefit of the judgment.
So,
That
my
is
lords,
the real
now may
import.
I respond
There
to
are-
this?
Just
Now
one
may
minute.
I respond to
There
this?
are, my lord, there are
My
three
lords-
parts of the, just 1 minute, Meenakshi. There are three parts. If your lordship will see page 5, the para in the lower half of the page, there are three places where the Supreme Court says, if you are appointed, we will protect you. That is the underlying order. If your lordship will see para 5, bottom of the page. Before us, two sets of parties are there. One set wants retention of the judgment in its present form. The opposing side alleges it would result in loss of employment to those who are already appointed
That
as
will
teachers in different states
My lords, may I
on the strength
respond?
of the B.Ed degree. Then again, my lord, 6 at the top, see what the court says, page 6 at the top. Now, having considered these factors, particularly the contention of B.Ed applicants, that they have entered into employment as per the qualifying criteria specified by the appointing authority, equity should go in their favor. This line is very crucial when we read it with page 7. Those candidates who have been appointed because they were qualified as per the criteria of the appointing authority have all been protected. It is only those candidates who were not qualified as per the state criteria and who secured interim
That is
orders.
also, Mr. Patwalia, I hope I'm pronouncing your name correctly.
Yes, absolutely, Lord. Absolutely, I'm grateful.
That is also subject to certain conditions mentioned at page 7.
Correct. So
Yes.
let us read it, Lord, because it was hotly contested.
We'll clarify that 1, 2, 3, 4. If this happens, retain them. If this happens, don't retain.
Yes, because then your lordship will have to read the first 4 lines of page 8 very carefully, because any court of law that their appointment would be subject to final outcome of the case, which might have been instituted by them.
In this
If the other
case,
side's interpretation is
candidates from
accepted
NPF
and
filed
nobody
an
is saved.
application in the Supreme
No,
Court.
this is not the object
Mr.
of the order.
Patwalia is not disclosing that.
The
On
object
11th of
of
October 2022,
just please don't
the
talk over me.
candidates from
You will
NPF
have
filed an
time.
application in the
Allow me to
Supreme
finish.
Court.
Allow me to finish. Don't get anxious.
Sir, at least take the right
Now
facts.
the point is,
Mr. Patwalia, please finish.
yes. So, my lord, I am only saying, my lord, the underlying object of this order at 4 places is anybody who has secured appointment should be protected if he is qualified as per the. It is only if you have secured an appointment when you are not qualified as per the state government's rules by securing an interim order that you are not protected, is my respectful submission.
My lords, may I
And
just
my
have
second
by the
respectful
clock,
submission is,
by the
if
clock,
this
my
interpretation
lords,
is not the correct one, then this order protects nobody. Then everybody goes, because everybody who is there was all subject to some writ or the other, and therefore this order
yes, my
becomes
lords, let
a
us now
completely odious.
let us look at what has
And
transpired here. 1 minute now,
my lord,
Mr.
also
Patwali. I think
Calcutta High Court, in fact, has also passed an order.
So, Patwalia, let Ms. Arora also.
my lords,
make-
just
One
few
last
minutes,
line,
and
one
I'll be
last
very,
line.
very
The
quick with
Calcutta
this.
High Court has passed an order on 19th, and the Calcutta High Court has said exactly what your lordship said when the hearing opened, that Supreme Court has decided the state government is to take action strictly as per the Supreme Court order.
Please give us the
So,
copy.
my lords,
Mr. Siddharth Shukla will have the order, my lord. Mr. Shukla can pass on to your lordship, my lord, that order.
so my lords, now where the state is
If your
making a
lordship, just one
submission
line,
and
one
Mr.
line.
Patwalia is saying, I think there is a need on how my lords will pass this order. May I just show very, very quickly few pages which I say is completely the Supreme Court order when it cannot be applied in respect of B.Ed candidates who have been appointed when my lord's direction to the state were already in place, that appointments, if any made, will be subject to the final outcome. The first order that my lords passed was on 7th of July 2022. My lords, the date is very important. My lords will find this at page number 1 and 2 of my lords compilation, to which Mr. Gopal Shankar Narayan was referring to. My lords, on 7th July 2022, on this date, no appointments had been made. But if any appointment, I take it, had been made, will be protected by Supreme Court order. But after this, definitely not. My lords, after this court passed an order on 7 July 2022, and the relevant part is recruitments in question and any appointment made shall remain subject to final outcome of this petition. My lords will find it at page number 2 of this particular compilation. Now, my lords, what happens is that on 11th October 2022, B.Ed candidates file an application before the Supreme Court for intervention. The matter comes up on 12th October 2022. Yes, for impleadment. And my lords, the matter comes up on 12th October 2022. The office report notes that this application was before the Supreme Court on that date. Please turn to page number 7 of this compilation and please see the order passed by the Supreme Court on 12th October 2022. Says, my lords, any steps taken during the pendency of these proceedings having impact on the controversy out of which these proceedings arise shall be subject to the final outcome or any further order that may be passed in this matter. Now, B.Ed candidates have approached through an impleadment, and this is an order that is passed by the Honorable Supreme Court. Now, my lords, the first advertisement thereafter of the state comes on 19th October and 16th of November. And my lords, another advertisement comes up on 26th of November. The writ petition is filed before the Madhya Pradesh High Court, and Madhya Pradesh High Court, by an order of 16th January 2023. All these orders are prior to these appointments. My lords, please turn to page number 8 of the convenience. Now, please turn to page number 8. This is not now Kesari Nandan, this is in Vipin Kumar Dwivedi. In this petition, the court says, all further actions by respondents will be subject to further orders of this court. My lords, the way Madhya Pradesh government has been going, my lords should see, because there's a direction to them and they are aware that they can't make these appointments. Now, my lords, what happens is that the appointments for the first advertisement, which is 19th October 22 and 16 November 2022, happened between 30th of March 2023, which is after my lord's order of 16 January 2023, to between 15th of April 2023. Would my lords be so kind and turn to the affidavit filed by the state of Madhya Pradesh before the Supreme Court? My lords will find this affidavit at page number 12, and the categorical statement made by state of MP is at page number 16.
All this has to be now going by the final
1
order.
minute now, Mr. Patwalia, you've had
it
your
has to
say.
follow all appointments
Yes.
which have been made
Now,
on petitions not filed by
Mr.
us
Patwalia,
will have to be
please
saved.
don't obfuscate the other side from presenting their case. You have said, please allow me now. Now, my lords, this is an affidavit filed by state of MP. Please come to page number 16. And this is very, very important. It says, my lords, in the second paragraph, first of all, there were total of 21,962 appointments, out of which 11,583 were given to the BEd. Now, what are the dates on which they have been given? Please look at the tabular chart below. A total of 16,000, out of which 8,799 were BEd. 10th of August, my lords, 1 day before the judgment. 1 day before the judgment, and I say this, my lords, this is very unusual.
Who would know
Let
when
me
the
call it
judgment is coming?
unusual.
Like this.
Page number 27. Certified should not be given these appointments. And I most humbly submit that today, in view of the Divesh Sharma judgment of my lords 11th August 2023, and including this clarification, the present appointments which as per state have been made on 30th of March 2023 and 10th of August 2023 are in teeth of that particular order of the Honorable Supreme Court, and my lords orders the two. My lords,
I can respond. It is, again, they have glossed over the words at page 8. They have been glossing over those words. Those words are crucial, that their appointment will be subject to final outcome of the case which might have been instituted by them. Supreme Court is crystal clear in saying so.
This is hair splitting, my lords.
Otherwise, Lord, nothing will be saved. Otherwise, this clarification is meaningless.
Mr. Patwalia, I think we have heard you.
All right.
Well, on facts, can I just take 10 seconds? Just 10 seconds only on facts, not more than 10 seconds. 10 seconds,
please tell them that is before the clarification.
If you don't mind,
don't give
please,
facts
if
like
you
this.
don't mind, please. The Honorable Uttarakhand High Court has followed retrospective application wherein interim order, any appointment post that out. Number 2, my lords, the Honorable Chhattisgarh High Court has again followed the same interim order, will not succeed in case they have been appointed post that interim order. So, my lords, when multiple high courts have been following, and if my lords would want, we'll put that in the written submissions, not more than.
I hope the council appearing virtually have concluded.
Yes, ma'am. Yes.
We are grateful, my lords.
We are extremely
Ready to give
grateful.
file a written
Very
submission
kind.
to be given, my lords.
My lord, we will get a chance. We are very sure. After these, all these people come to the verbal hearing, and also like to address because of them have not. Let them address. Lord, we are silent. After that, my learned advocate general is also there.
The advertisement was issued once the first advertisement which was issued.
I think the learned advocate general has the right to
Yes,
first audience. First audience, yes.
That is
First, if you lordship can kindly see, there are 5 writ petitions in which it is said whether the interim order was passed. Your lordship can kindly see WP number 13768 of 2020. Order. We just discussed manner. If we implement the directions of the Honorable Supreme Court, there was no interim order passed by your lordship. Now there is only one writ petition. Now they came before your lordship. Now then they could not take up the selection process. All they are raising, interveners are raising objections that they cannot maintain their writ petition. Now the issue to be taken into consideration before your lordship is, while learned friends who are appearing in that manner, instead of addressing your lordship and assisting several appointees who are having qualification of BA. Now, whether it is speeded in the writ petition, whether they have raised any grievance with respect to this category of candidates who have taken up the selection process and ultimately appointed by the state. So all these things are required to be seen, and therefore, my lord, the objection which we have made to go to the roots of the matter, they cannot maintain that writ petition, and therefore, my lord, I am making the most humble submission that this objection which we have raised, my many friends have raised, my lord, they are required to address and assist your lordship on this issue. And once your lordship is satisfied, yes, then their writ petition, then my lord, whatever direction which your lordship will pass, will bow down to it.
That is the first case.
My lords, may we respond?
First,
Only in the case of inquiry number south.
No, my lords, also Vipin, also in the case of Vipin Kumar Dwivedi, order was passed on 16th of January 2023. The prayers made in all these petitions are broad and wide. in fact asking that B.Ed are not qualified at all. And my lord said that appointments, if any, will be subject to further orders of this court. It is at page number 8 of that compilation.
Do not have a legal qualification, have the protection. So the B.Ed candidates go out completely. My issue is with the B.Ed candidates remaining in the room. That's my problem. They cannot be eligible at all. And that is why I was here in the Supreme Court as well, arguing this very issue before the Supreme Court. There was no objection taken to my locus standi here. I'm very surprised that somebody is taking it. Yes.
Were appointed and saved by the Supreme Court.
August, in fact, the day before the Supreme Court judgment, the notifications have been issued by the Madhya Pradesh government intending to appoint them, but not actually appointing them. That's a very important distinction to be borne in mind. There are two swaths of appointments that have taken place in Madhya Pradesh. One on an earlier date, and the second the day before the judgment.
Yes.
Also, the entry order, all the further action by the respondent will be subject to other law.
Yes.
Similarly, one set of petition, KG Nandan and
सर पूछेंगे एक मिनट बोला एक पेज का जो ठाकुर साहब बता रहे हैं आपको सर उसको फिर क्लियर किया था 28 को भी by the honorable court. It is only when by the initial order which was passed on 16th of January 2000.
If you see the 16(1) order, it's of a very generic nature. It covers everything. Further action by the respondents will be subject. Further action means recruitment plus appointment.
Your Lordship may kindly see the subsequent interim order on 28th of August 23 in the same writ petition.
Yes, yes.
That was the intent of the honorable court that the appointment shall be disturbed, but the subsequent interim order will be passed by the court. But then, my lord, specifically this court was kind enough to wait. And this, the order was passed on 28th of August 2023.
Yes.
Now, by the way,
What other relief
This
you
is my relief, I am not here the appointment. Answer.
then what are you claiming?
Relief.
Yes.
I have challenged only the validity of the rule of the state government operation July 28.
Which rule? Where is that? Where is that challenge in the prayer floor?
Para 7.5, Manoj, the page 30 is the challenge to the rule. Para 7.5, page 30.
Advertisement date. 16/2022 attendance only the extent of Madhya Pradesh primary teachers relevancy test 2023. Restraining the B.Ed degree holders candidate for appointment on the post of primary teacher, school teacher, and to give appointment only to those who are DLED diploma holders candidate.
This is already granted to you by the Supreme Court. Granted ho gaya na ye to. They have said that DLED is the prescribed qualifications. And so far as B.Ed appointees are concerned, they have passed certain orders protecting some appointments, not protecting some, subject to certain conditions. Are we going to sit over the Supreme Court? Then Supreme Court has decided that case. Supreme Court has upheld the Rajasthan High Court order. Rajasthan High Court quashed the notifications. This order of the Supreme Court also covers all other cases mentioned, I think, in the last paragraph.
All other states also. It covers all states.
It is clear that directions contained in the order shall not be confined to the applicant. date only, and shall cover all cases which may be pending in different judicial fora in any state or union territory on the same point of view. What remains now? Anything else? Who? No, there are only two petitioners there in this petition. Which petition? In which case?
Point one, will for the very, they have not appointed. And Tarun Agrawal, there is, and petition, they are also not appointed.
So this Vipin Kumar Dwivedi, what diploma holder or
Diploma, all in the
diploma holder?
money stand is not. They also not got appointment. On the petitioner or diploma about the unit petition.
There are two petitions. Same petition.
Yes.
The prayer are same or different? Same. Copy paste.
My lords, it will be fortunate if they are copy paste because then they are wide in nature and they are then in rem. So even one petition will cover the relief for everyone else who's similarly situated.
They'll come back to it.
That's the yes. Yes.
My lords, with that, I think it's a writing on the wall. If my lords have heard the argument of the learned AG, my lords, then it's a writing on the wall. My lords, the learned AG has in no uncertain terms suggested a particular position, and which I guess will be the position of the state. I would request my lords to my lords.
Also argue. Yes, Mr. Devi.
My lords, please see. My lords, notice few bits. So this advertisement is issued on 6/1/2020. Why I am drawing the attention of the lordship? I relate it to the order passed by the Supreme Court.
No, Mr. Gilia, you are appearing for?
I am appearing in K3 Nandan as well as this Vipin Kumar, we earlier made intervention applications. Our applications are allowed, we are included as respondent.
You are BID appointees.
No.
Yes.
Now, my lords, kindly notice, the advertisement is issued on 6/1/2020.
Yes.
The examination is held on 5/3/2020. 5/3/2020.
After more than 2 years.
Yes.
This is written exam.
But this was delayed due to COVID and all the certain examination.
All right.
Then, my lords, this petition was filed on 13/6/2022. K3 Nandan's petition
13/6.
2022. And it was filed by these petitioners who had already participated in the process of selection. They went by the conditions of the advertisement, participated in the process, and thereafter they filed this petition on 13/6/2022. The interim order was passed on 7/2022.
Yes.
During pendency of the petition, both the petitioners got selected and appointed.
When was that?
Well, their appointment orders are fixed.
Well, the appointment orders.
Well, both are appointed. Well, we had supplied the copies of their appointments. I'll just give the dates.
4/4/20.
4/4/23.
Both. Same date.
Yes. They both were appointed.
Yes.
Now, can you see the relief clause words, which one of have just seen? relief clause in the writ petition. Because it has been said that their grievance still subsists. Now, how it subsists, my lord, is relief. 7.1 is, my lord, that relief they have already got. As per my lord, 7.1 is concerned, that NCT regulations, my lord, that has already been declared, my lord. Now, can we see 7.2? That the Honorable Court may kindly be pleased to issue an appropriate writ order or direction not to treat BA candidates eligible for the post of primary level teacher in schools under RT Act 2009 without passing NCT prescribed this course. Only BSTC candidates at selection process of primary level teachers above said BA teachers who are not possessing adequate training and qualification for working as primary teacher to teach students in class 1-2. This related also becomes instructors with their appointment. Now, next, to this Honorable Court may kindly be pleased to the extent that the same relief to this, there are very fine aspect involved in this. Kindly see page 7. Every word has a meaning. And as the law says, that there is nothing which can be termed as superfluous. Please have a look on page 7. As it appears that a large number of candidates with BA degree had already been appointed on the basis of eligibility criteria application to have prospective operation. But prospective operated without any candidate had gone to the court saying that we have been selected, yet the government is not giving us appointment. And then the court would have said that grant them appointment. Court would have directed the state government to grant them appointment, but their appointment will remain subject to outcome of the case. The situation is like this here, that the Supreme Court says that the proceeding instituted by them. Now, here is a situation where advertisement is issued on 6/1/2020. Writ petition is filed on 13/6/2020 after participating in the process. The interim order is passed at our back. We are not participating in the proceeding at that stage. So there is a difference now that if these proceedings were instituted by these BA candidates, and if this entry order was passed, at their instance, it would have a different connotation. Then, the entry order passed in a petition which is passed, that makes a difference. That the appointments, firstly, we say that this Kesri Nandan's case, this entry order was passed in the Kesri Nandan's case, which has already been rendered in process. Now, second aspect is this, that even if it is assumed that this entry order survives, even then this entry order is not passed by on a petition filed by the candidate of BA category. This is the petition filed by the DLF candidates. Now, the learned Advocate General has already pointed out to your Lordship the order passed by the Calcutta High Court. And the Calcutta High Court has very categorically said that because there is nothing to adjudicate now. As far as this aspect is concerned, the Supreme Court has said that this is the order, and now this order has to be implemented, and everybody has to implement the order as per the letter and spirit as per the direction passed by the Supreme Court. Therefore, my submission is this that.
So the petitioners in these, in the first case and the second case, petitioners are diploma holders. And in the third and fourth and all
petitioners in the first case, also they are also the DLF.
They are diploma holders.
Yes, they are
diploma holders.
Diploma. Yes.
And what about third and up till?
Well, they all are diploma.
All are diploma.
All are diploma. That is what I say. That
all are diploma holders. All of
There
them.
would be no cause for the B.Ed candidates to come to court, my lords. It's obviously only the diploma candidates will come to court. This is such a twisted interpretation. If you see that, if the B.Ed candidate had come to court, he will not get a protection. That is the suggestion here. Because otherwise everybody else gets
In
protected.
two courts,
but
the
a
B.Ed
candidate who
candidates
comes
went.
to court will not get a protection.
B.Ed candidates
These
went
are-
to court in Rajasthan, and B.Ed candidates went to the Supreme Court in Chhattisgarh.
This was a Madhya Pradesh application in the Supreme
Was
Court.
for the simple reason that the Rajasthan
Let-
government did not
let-
accept government's 2018
let-
notification because
No,
Rajasthan
please,
government
India
did not
complete.
include the B.Ed in the exam.
Please let Mr. Gildea complete.
Yes.
Yes.
my submission is this. The order passed by the Supreme Court has to be read in that respect. And with that followed,
So according to you, all these protection is only to B.Ed appointees.
this protection is
To B.Ed appointees.
to be appointed now because there are not the conditions Supreme Court has imposed.
All these conditions imposed relate to people who are B.Ed and were appointed and then approached the court.
Yes.
Did not.
In some states, not B.Ed.
These conditions apply.
That would never happen.
In some states, the rules did not permit B.Ed
This
to
is only
complete.
about
For
Madhya
example, Rajasthan. Rajasthan rules made B.Ed ineligible.
Rules permitted B.Ed.
Here, MP rules permitted.
Yes.
Rajasthan rules did not permit. So Rajasthan, the B.Ed candidates went to court and got an interim
What I
order
said.
saying the
Protection.
B.Ed and got an
Otherwise,
interim
the
order.
B.Ed candidates would have the protection.
That Rajasthan High Court had already struck down that qualification, and the advertisements came after that.
Okay.
Let
Now-
Mr. Gilyal complete, please.
Aspect is concerned, we need not to go into that now. The Supreme Court evaluates that now what aspect is said now, it's not immaterial now. The Supreme Court said that our judgment applies prospectively. Being there by the sake of the decision of the Supreme Court, the B.Ed candidates are not to be treated as eligible, and their appointments have been protected. And the rules of Madhya Pradesh, now they permitted the B.Ed candidate, as the rule existed at the time of issue of advertisement, the rules permitted the B.Ed candidates.
No, and rules permitted the B.Ed candidates also to be eligible.
Yes, yes,
Also,
yes, also.
besides diploma.
Yes, diploma in B.Ed. And also, please see, it has been always been said that if these seats are given to B.Ed candidates, what will happen to B.Ed candidates because they can only go for the primary teacher's appointment and they have no other avenue left open. This is absolutely incorrect. Please go through the rule. Rules, my lord, they permit the B.Ed candidates not only to participate for primary teacher, but they are also eligible for middle teacher. This has all.
Column in that schedule.
Rules are.
This is
Column 5 of Schedule 3. That's what our prayer was for.
P1 is Vipin Kumar, 595. My lord, P1 in both the cases.
Please see room, page 70.
Column 5 Schedule
71 or 38?
No, it's not 70.
38.
Or it is rules are in Hindi,
38. Page 38.
page 30. And in these rules, the what the nature of
कम से कम 50% अंकों के साथ हायर सेकेंडरी या के संपर्क
Maharashtra, please see
अथवा 50%
Athwa is or.
अथवा 50%
Athwa is or.
Athwa,
Or.
yes. Schedule 3, Maharashtra, looking schedule 3. Yes, माध्यमिक शिक्षक
प्राथमिक शिक्षक का है ना ये?
प्राथमिक शिक्षक के लिए प्राथमिक शिक्षक, yes. What I was trying to point out that DLED candidate is not only eligible for प्राथमिक शिक्षक, that is the primary teacher, but they are also eligible for the middle teacher. That is incorrect.
No, we are not here to adjudicate.
Yes, that is
Everything has been done by the Supreme Court.
Yes.
We can't enter into that field of adjudication.
Now, प्राथमिक शिक्षक की qualification, Maharashtra, please have a look. प्राथमिक शिक्षक. Now, it is Maharashtra. कम से कम 50% के साथ हायर सेकेंडरी का क्वालिफिकेशन के प्रारंभिक शिक्षा में 2 वर्ष का डिप्लोमा के साथ 50% अंकों के साथ स्नातक अथवा शिक्षा स्नातक B.Ed.
I'm sorry to interrupt, my lord. That has not been struck down. Your lordships will have to strike it down. It's the Madhya Pradesh rules. Nobody else has struck it down. In terms of Supreme Court's finding, your lordships will have to strike it down formally. That's prayer 7.5 of our writ petition. Nobody has struck it down so far. Your lordship will have to strike it down.
And what happened in Rajasthan?
In Rajasthan, it was the NCT notification, my lords.
Rajasthan,
The underlying one, that was struck down.
Rajasthan, the rules did not permit B.Ed to.
The rules did not
compete.
permit, so there was no challenge to the rules.
Rajasthan
The challenge
rules did
was to
not
the
permit
NCT
B.Ed.
notification. And the court in
Rajasthan
fact
rules did
held
not
over there
permit.
that despite the Rajasthan rules not having been amended in accordance with NCTE, you had deprived B.Ed candidates from taking part. So there the Rajasthan High Court said you should have allowed B.Ed candidates to take part until the stage at which the NCTE notification was formally struck down. But
So
here the fact
Rajasthan,
that
what happened, my lord, the Rajasthan rules did not allow them. The NCT notification said they are eligible. The advertisement did not allow B.Ed, and therefore the B.Ed people went to the High Court, saying we should be allowed to
The
compete.
light of quashing of this NCT notification,
Yes,
rule also has to be struck down.
correct,
Yes, it
correct,
has to.
correct.
It has to
Now,
go.
Yes.
from now the rule, now once the notification goes, the rule also cannot survive because the court says B.Ed are not eligible.
Since the mother body of teaching education.
Correct, correct, correct. So therefore the question arises, what happens to people who were eligible under the state?